Hi, Bill Henshaw here again. We're continuing the introduction of our new YouTube channel, Win in Court, and we've discussed several items to this point. We're now going to go on to the objection to entry of plea. And this is a major big deal. You get to the quote-unquote arraignment, and this is where they try to intimidate you at first. So that said, those of you that have ordered my constitutional defense documents, aka earlier as document packets, received my objection to entry of plea with the notation it was a little known but major constitutional issue, which is true as attested to by the 9 old parts, aka the U.S. Supreme Court, in Crain v. United States, 162 U.S. 625. Yet they think, quote unquote, that Crain is not binding case law. Thus, I have a little test for viewers here, the success of which will be rewarded with an extra discount on my already modestly priced constitutional defense documents, information on availability of documents at uwinincourt@gmail.com, or for those having already my documents, an extra complimentary phone consultation or two, recognizing that such success is a measure of proper perspective of the subject matter and probable success in quote-unquote court. Therefore, I ask you to tell me why the bastards think that Crain is not binding case law, and why one can tell at a glance that the bastards are wrong yet again. And this is a very big deal indeed, as future videos will discuss, since a judge, aka Black Robe Bastard, cannot enter a plea for you, since he is not your attorney and does not have any known fiduciary relationship with you that would permit such action. With my constitutional defense documents and time and effort studying the unopposed issues I advocate, you will learn that what you have been fraudulently misled to believe are state judicial courts of common law general jurisdiction are in fact federal insular territorial tribunals, aka administrative tribunals, which require your consent to have any jurisdiction at all, since they cannot rule on the constitutionality of any statutes, aka corporate bylaws, and this makes any allegedly applicable statute, rule, or regulation at all null and void as being a bill of attainder, the taking of property or liberty without judicial process, which is a clear and unambiguous violation of at least Article 1, Section 9 or 10, as the case may be, of, and or the 9th Article of Amendment 2, the Constitution for the United States, 1787-1791. And the entry of the plea is a highly jurisdictional act, which is why you do not enter any plea and stand mute. Now the quote-unquote judge enters a plea for you, thinking that he has the statutory authority to do so, but this is not true, and is yet another big tell. In California, we have Penal Code Section 1024, which purportedly permits the entry of a plea by a quote-unquote judge, but this statute has been on the books for 150 years without any case law decisions. For those of a suspicious nature, let alone a pathological pessimist like me, is left to wonder why this is true. While 42 U.S.C. 1983, the main civil quote-unquote rights statute, which virtually everyone knows about, and which emanates from Section 5 of the non-existent 14th War Amendment, quote-unquote, has 3 volumes in the U.S. Code annotated. Stay tuned for another video on this intriguing issue, exposing a clever sleight of hand of which even Harry Houdini would be envious. Now remember to like these videos, send comments to me, tell your friends, and email me at uwinincourt@gmail.com.